Today, we'll be presenting the Lankhorst-Hohorst GmbH versus Finansman Steinfurt case. The outline will be the facts and background, the legal issue, the applicable sources of law, the court's reasoning, and finally, a brief conclusion on the court's decision. Lankhorst-Hohorst is a limited liability company incorporated in Germany and engaged in the sales of boating equipment and other leisure products. In August 1996, the company increased its share capital to Deutschmarks 2 million. Lankhorst-Hohorst, a parent company, is Lankhorst-Hohorst BV. Moreover, Lankhorst-Tesla is the company of the latter. Both companies are registered and have their offices in the Netherlands. In December 1996, LTBV granted Lankhorst-Hohorst a 10-year loan of DM3 million, repayable on an annual installments of DM300,000 and with an annual interest rate of 135,000, which is equivalent to 4.5% interest rate. The loan, accompanied by a letter of support, allowed Lankhorst-Tesla to waive debt-related claims from third-party creditors against Lankhorst-Hohorst. Also, it reduced the level of indebtedness and therefore its interest burden with third-party creditors. The tax authorities, when assessing the tax declaration, treated the interest paid to the parent company as a distribution of profits and taxed it as such at a rate of 30%. This is considered to be the main reason as to which the companies decided to come up with legal disputes.
The main national legislation of relevance to our case is the Law on Corporation Tax, paragraph 8A1, which says that a loan capital should be regarded as a distribution of profits if a company had obtained such a loan from a shareholder not entitled to give out loans. So this is the case of intragroup transactions between a parent company and a subsidiary. And if the loan capital is more than 3 times that of equity capital. And so this all applies unless, point 2, the taxpayer could demonstrate that such a loan capital could have been obtained from a third party under the same conditions. Paragraph 51 is also of relevance, as well as the case Commission versus France and Royal Bank, and the one of the Royal Bank of Scotland, which said that a national of a member state who has a holding in the capital of another company in another member state is essentially exercising his right of establishment. Commission versus Belgium said that in order to ensure the coherence of the whole tax system, a restriction of the free movement of persons may be justified. This one is particularly important because it was used as a defense by the German government in our case. The thin capitalization rule. It's firstly of importance because when choosing or when facing a decision between debt or equity financing, and its main aim is to discourage debt shifting. So countries are able to limit the amount of interest a business can deduct for tax purposes. And this has been a problem because tax authorities are concerned about the excessive interest claims such a company or subsidiary claim. For example, LH Lankhorst, the German company, reduced its bank borrowing from 3.7 million to 900K Deutsche Marks, and thus was able to reduce its interest charges drastically. The problem was moreover exacerbated because of the fact that it's an intragroup transaction. Lastly, thin cap rules are measured through debt to equity ratios. As you've seen in paragraph 8 of the previously mentioned legislation, if the total debt to equity ratio exceeds 3:1, the transaction is considered a distribution of profits. The main legal issues. The tax authority took the view that the interest paid to LTBV was equivalent to a covered distribution of profits as described under paragraph 8A. Accordingly, it taxed the company at the rate of 30%. According to the Finanzgericht, the exception laid down under paragraph 8A had 2. The one I mentioned of a company proving that it could have obtained such a loan from a third party with the same conditions could not apply in the main proceeding because it was clear of the over-indebtedness of the company and its failure to provide security. So it was pretty much unreliable and unreasonable to claim that Lankhorst, the German company, could have obtained a loan from a third party under the same conditions that it obtained from its parent company, the Dutch LTBV. The question for the preliminary ruling to the ICJ was whether Article 43 precludes the national rule contained in the paragraph 8 of the German legislation based on the requirement of the freedom of establishment. So in other words, it's asking whether the German capitalization rule is contrary to European community law based on freedom of establishment.
Okay, I'm going to talk now about the court's reasoning and the analysis. So first, let's talk about the obstacle, whether the court finds one with regard to the freedom of establishment. And afterwards, we're going to discuss whether there was a justification brought forward justifying such a legislation in place. So first, the court finds that there is an existence of an obstacle to the freedom of establishment because it applies only to shareholders which are not entitled to corporation tax credit. Who are those shareholders which are not entitled to corporation tax credit? Basically, the ones which are non-resident of Germany. That means all companies having a seat abroad and specific German legal persons, however, not ordinary for-profit organizations in Germany. Making the case of unequal treatment, basically the first example is the one of the case. So we have a parent company in the Netherlands and a German subsidiary. And as of the German law, the parent company, the shareholder, is not entitled to corporate tax credit. That means that the law is not applicable and the interest to the shareholders are regarded as covered distribution of profits. Therefore, they may not be deducted to lower the taxable base of the subsidiary in Germany. In the second case, it's the same situation. However, the parent company is a German one. In such a situation, the shareholder is entitled to corporate tax credits and the legislation is not applicable, so that the interests to the shareholders of the subsidiary are not regarded as covered distribution of profits, and the interest may be deducted to lower the taxable base. So basically, yes, because of the corporate seat, there is an unequal treatment based on nationality, creating an obstacle to the freedom of establishment found by the court. Are there any justifications? First, tax evasion. Basically, this creates a situation where the subsidiary and the parent company are having the seat in different countries, and the tax debt is therefore likely to be transferred from one country to the other. So it would be the case that the total tax revenue of the country of the subsidiary, in this situation Germany, is lower because the taxable base is reduced by the interest deduction, plus the interest received will be subject to the income tax abroad. So Germany is worse off in such a case in terms of overall tax revenue. And this idea of thin capitalization, meaning using the interest to reduce the overall taxable base, might be a situation of tax evasion, having in a case where the shareholder is having the seat abroad. So what is the court's answer? The court is reasoning that the legislation constituting such a situation does not have the specific purpose of preventing wholly artificial arrangement in this situation. So the general application to all companies having their seat outside of Germany is not appropriate because it is not automatically establishing a situation carrying a risk of tax evasion, because shareholders are receiving interest will be also subject to the national tax system, meaning in that case, the Netherlands. So why is this not a case of abuse? In the facts of the case, the subsidiary receiving from the parent company the loan uses this loan to reduce its other debts where the interest carried is higher. So the overall taxable base reduced by the interest payments will be higher because the interests due are reduced by granting the loan. So therefore, this is not a situation of abuse or tax evasion, and therefore the court rejects the justification. Second, the coherence of the tax system as a justification. Basically here, the argument is that this legislation is necessary to ensure such coherence, and that the legislation is in line with the arm's length principle. So arm's length principle meaning granting, or it's the German legislation is creating an exception with regard to this principle, because it excludes the case where a loan could be obtained under similar conditions. And the reasoning of the court is basically that, according to the Bachmann and Commission versus Belgium case, such an argument might be okay with regards to the free movement of persons, but this is a case of freedom of establishment, as well as that there's no direct link established. So the subsidiary of a non-parent company is subject to less favorable tax treatment, as well as that the German government does not provide a measure to offset this treatment. Therefore, the court rejects the justification. Third, the effectiveness of fiscal supervision. So the argument is basically that this legislation is justifying because it is necessary for the effectiveness of fiscal supervision. And the reasoning of the court in this situation is that no proper argument is provided to show that this is actually the case, and that it enables the German tax authorities to supervise the amount of taxable income. So also this is rejected. Overall, yes, there is an obstacle based on unequal treatment, and all justifications were rejected by the court, so that we can say that Article 43 EC is to be interpreted as precluding a measure such as that contained in paragraph 8A1 head 2 of the Law on Corporation Tax. Thank you for listening.